Moving on, former President Trump has been ordered to answer questions under oath as part of a fraud investigation into his company. A New York judge ruled yesterday that the former president, Ivanka Trump, and Donald Trump Jr. must obey the subpoena from New York Attorney General Letitia James.
A federal judge just found probable cause for criminal contempt against the Trump administration, and what sources are calling an unprecedented escalation could force Donald Trump himself to testify under oath about defying court orders. We're not talking about civil disagreements or procedural disputes. We're talking about reports that Judge James Bosberg has erupted over the administration, ignoring his explicit order to halt deportation flights, that planes kept flying after the judge said stop, that officials provided contradictory explanations about who authorized the defiance, and that the judge is now demanding sworn testimony from top Justice Department officials about the chain of command that led to court orders being violated. Sources suggest if those officials point upward, if they testify they were following presidential directives, the judge could compel Trump to answer questions under oath about whether he personally ordered federal agents to defy judicial authority. And for someone who invoked the Fifth Amendment over 400 times in one deposition, who has spent his entire career avoiding sworn testimony, that possibility might represent his absolute nightmare scenario coming true. But before we break down how this contempt finding could force Trump into testimony he's desperately tried to avoid, real quick, you cannot trust mainstream media to explain what it means when federal judges find probable cause for criminal contempt against a sitting administration. That's why we built Patrick Smith Show, to bring you real stories, real context, and no corporate spin. If you want analysis that actually connects judicial contempt findings to the constitutional crisis of presidents defying courts, hit that subscribe button right now. Because what Judge Bosberg is doing could test whether courts have any real power to enforce their orders against executive branch that refuses to comply. Your subscription actually matters here. All right, let's get into what actually happened and why sources suggest this represents one of the most serious confrontations between judiciary and executive branch in modern American history. Because Judge Bosberg didn't just express concern or issue warnings, reports indicate he made formal finding of probable cause for criminal contempt. That's extraordinary legal determination that evidence exists supporting contempt charges. He allegedly called the administration's conduct blatant disregard for the court's order, and described it as exceptionally uncommon and highly contentious defiance of judicial authority. Those aren't mild criticisms. That's a judge documenting that the executive branch violated its constitutional duty to respect judicial rulings, and now he's reportedly working his way up the chain of command, demanding sworn explanations. If subordinates testify they were following orders from above, if the paper trail or testimony leads to the Oval Office, Trump could face choice between testifying about authorizing contempt or refusing to testify in ways that make him look guilty. Neither option might be politically or legally survivable if Democrats take Congress in November and use contempt findings as impeachment evidence. Let's start by documenting exactly what happened that led Judge Bosberg to find probable cause for criminal contempt. Because understanding the sequence of events helps explain why the judge is so furious and why this could become constitutional crisis. Sources indicate Trump administration was using the Alien Enemies Act to conduct fast-track deportations of alleged Venezuelan gang members. That's controversial law from 1798 designed for wartime that Trump has allegedly tried applying to immigration enforcement in ways that bypass normal due process protections. Civil liberties groups challenged the program, arguing it violated constitutional rights. Judge Bosberg reportedly agreed there were serious problems and issued emergency order halting the deportation flights while legal issues could be sorted out. That's standard judicial procedure when constitutional violations are alleged. Court stops the potentially illegal conduct while it reviews the merits. Executive branch is supposed to comply with that order even if it disagrees and plans to appeal. But reports indicate the administration didn't comply. Deportation flights continued even after Judge Bosberg's order. Planes kept taking people to El Salvador despite explicit judicial directive to stop. When the judge found out, sources suggest he was absolutely furious. Not just concerned or disappointed. Furious that his lawful order had been defied. Think about what that defiance means. It's not executive branch disagreeing with court's interpretation of law and appealing. That's legitimate within constitutional framework. It's executive branch simply ignoring what court said. Continuing conduct that judge specifically ordered halted. That's not operating within checks and balances. That might be one branch of government deciding the other branch's orders don't matter. And now, sources suggest the administration's explanations made things worse rather than better. Reports indicate there was confusion about who knew what and when. Different officials gave contradictory accounts. Some claimed they didn't know about the order. Others suggested there were communication breakdowns. The overall impression allegedly was either deliberate defiance or such administrative chaos that the government couldn't ensure compliance with clear judicial directive. And both explanations are damning. If the defiance was intentional, that's criminal contempt. Officials deliberately violating court orders because they disagree with them. If it was chaos and incompetence, that raises questions about whether administration can function within constitutional constraints. Either way, Judge Bosberg apparently concluded the conduct warranted formal contempt proceedings. But let's talk about what it actually means when a federal judge finds probable cause for criminal contempt. Because this isn't just harsh criticism or stern warnings. Sources suggest it's formal legal determination that launches proceedings with potentially serious consequences. Criminal contempt is different from civil contempt. Civil contempt is designed to compel compliance. Court can impose fines that escalate until someone does what they're ordered to do. Criminal contempt is designed to punish violations that have already occurred, to hold people accountable for defying judicial authority. Reports indicate Judge Bosberg's probable cause finding means he believes there's sufficient evidence that contempt occurred. That's similar standard to what prosecutors need for bringing criminal charges. Not proof beyond reasonable doubt yet, but enough evidence to proceed with formal proceedings. And once those proceedings begin, sources suggest officials could face fines, or potentially even jail time depending on how egregious the contempt is determined to be. Think about what tools judges have in contempt proceedings. They can compel sworn testimony from anyone involved in the violation, can order production of documents showing who made decisions, can impose sanctions on individuals who participated, can refer matters to prosecutors for criminal charges if contempt was willful. All of those powers allegedly give judges significant leverage to enforce compliance even against resistant executive branch. And there's reportedly another element that makes contempt findings particularly powerful. They don't require long trials or complex proceedings. Contempt authority is inherent to judicial power. Judges can act relatively quickly to punish violations of their orders. That means Judge Bosberg could potentially move fast to impose consequences if he determines the evidence supports criminal contempt charges. But sources suggest what might make this situation unprecedented is that the contempt involves highest levels of government. This isn't minor official defying local judge. This could be systemic defiance involving Justice Department, Department of Homeland Security, possibly the White House itself. When contempt extends that high, enforcing it becomes complicated by separation of powers, questions, and practical issues about compelling compliance from co-equal branch of government. Share this video with everyone you know because there's reportedly another dimension. Judge Bosberg has also found that the deportation program violated due process rights. People were removed from the country without proper notice, without meaningful chance to contest their deportation, without opportunity to dispute gang allegations against them. Those are fundamental constitutional protections that apply to everyone in the United States, regardless of immigration status. When you combine due process violations with contempt of court for ignoring orders to stop those violations, you have a pattern of lawlessness that could become central to impeachment proceedings if Democrats gain investigative power. But here's where this situation could become most dangerous for Trump personally. Sources indicate Judge Bosberg has ordered Justice Department officials to provide sworn declarations explaining how the decision was made to let deportation flights continue despite his order. Who authorized it? Who knew about the court order? Who decided to ignore it? Those are the questions he's reportedly demanding answers to under oath. And the judge has allegedly made clear that if written statements are inadequate, he'll require live witness testimony. He's already directed top DOJ officials to testify about what they told DHS and White House officials on the day of the order. Reports suggest he's working methodically up the chain of command, starting with lower-level officials who might have been involved, moving to senior Justice Department lawyers, then potentially to cabinet officials, and ultimately, sources indicate, to whoever made the final decision about whether to comply with judicial order. Think about what happens if testimony from subordinates points upward. If Justice Department lawyers testify they informed the White House about the order. If DHS officials say they were following directives from above. If everyone down the chain says they were acting on orders rather than making independent decisions. That paper trail could lead directly to Trump. And if it does, Judge Bosberg might have grounds to compel presidential testimony about who authorized the contempt. Trump's lawyers would fight that with everything they have. Sources suggest they'd claim executive privilege, argue that president can't be compelled to testify about official decisions, invoke separation of powers. But Judge Bosberg has already demonstrated he's not intimidated by executive branch resistance. He's already found probable cause for criminal contempt. He might not accept privilege claims without requiring serious legal justification for why president should be exempt from answering questions about defying court orders. And now there's reportedly another element. The specific officials Judge Bosberg has targeted include senior DOJ immigration lawyers and deputy assistant attorneys general. These are people who would have been directly involved in communications between Justice Department, DHS, and White House. Their testimony could establish timeline of who knew what when, could document whether White House was informed about the order and directed agencies to ignore it. And that documentation could become evidence in both contempt proceedings and potentially impeachment articles. But let's talk about why testifying under oath represents Trump's absolute nightmare scenario and why he spent his entire career avoiding it. Because sources suggest Trump's relationship with truth makes sworn testimony extraordinarily dangerous for him. In the New York civil fraud investigation, reports indicate Trump invoked the Fifth Amendment more than 400 times. That's not typical behavior for someone who has nothing to hide. That's someone refusing to answer question after question because truthful answers might incriminate him. And there's reportedly a pattern across Trump's depositions. He's evasive, combative, makes claims that evidence contradicts. Sources suggest he's not disciplined enough to stick to carefully crafted answers. He tends to embellish or exaggerate in ways that create problems when statements can be checked against documents. When you're under oath and lying is perjury, that lack of discipline becomes existential threat. Think about what Trump would face if compelled to testify about deportation flights. Judge Bosberg would ask specific questions. Did you know about my order halting flights? Who told you about it? What did you direct officials to do in response? Did you order them to continue flights despite the order? Those are simple factual questions that require yes or no answers. Trump can't deflect or change subjects the way he does in interviews. He has to answer, and whatever he says under oath becomes evidence that can be used against him. And sources suggest there's no good option for Trump. If he tells truth and admits he knew about order but directed officials to ignore it, that's confession to contempt of court. That's president admitting he ordered subordinates to violate judicial authority. If he lies and says he didn't know or didn't give that directive, officials who testified before him could contradict his statement, and then he faces perjury charges on top of contempt. If he invokes Fifth Amendment, that makes him look guilty, even if technically it can't be used against him in criminal proceedings. It could absolutely be used in impeachment proceedings as evidence of consciousness of guilt. Share this with everyone because there's reportedly another dimension. Trump's history of defying courts and attacking judges who rule against him could become relevant in contempt proceedings. Judge Bosberg could point to pattern of Trump treating judicial orders as suggestions rather than binding directives. That pattern could support finding that contempt was willful rather than accidental. That Trump deliberately defied court because he doesn't believe judges can constrain presidential authority. And willful contempt carries harsher penalties than contempt through negligence or mistake. But step back and look at what this situation represents for American constitutional structure, because sources suggest this isn't just about one deportation order. This could be a test of whether courts can actually enforce their rulings against president who refuses to respect judicial authority. The entire American system depends on branches of government respecting each other's constitutional roles even when they disagree. Reports indicate the framers designed separation of powers specifically to prevent any branch from becoming all-powerful. Courts interpret constitution and laws. Executive branch executes those laws as interpreted by courts. Legislature makes the laws. Each branch has tools to check the others, but the system only works if branches accept those constraints. When president simply ignores court orders, sources suggest the whole framework breaks down. Think about what happens if Trump successfully defies judicial authority without consequences. That establishes precedent that future presidents could exploit. If courts can't enforce their orders against resistant executive, judicial review becomes meaningless. President could do whatever he wants regardless of constitutional limits. Just ignore judges who try to stop him. That's not rule of law. That's rule by whoever has most power. And there's reportedly another element. Legal scholars are describing Judge Bosberg's aggressive response as an attempt to prevent that breakdown, by finding probable cause for contempt, by demanding sworn testimony, by building detailed record of what happened. He's showing that courts have tools to fight back against executive defiance, that judges aren't powerless when presidents ignore them, that contempt power and compulsory testimony authority give judiciary real enforcement mechanisms. But sources suggest the question remains whether those tools are sufficient. Can Judge Bosberg actually compel Trump to testify if Trump refuses? Can he impose meaningful sanctions on administration that continues defying orders? Or do presidents have so much practical power that judicial authority becomes theoretical rather than real? The answers to those questions could determine whether America still has functional separation of powers or whether presidency has become effectively unchecked. Make sure you're subscribed to Patrick Smith Show because there's reportedly connection to impeachment. House Resolution 353, the impeachment resolution already filed against Trump, includes article charging obstruction of justice and breach of duty to faithfully execute laws. Defying federal court order fits squarely within that charge. Judge Bosberg is building evidentiary record, documenting the contempt, compelling testimony, establishing who was responsible. All of that could be used in impeachment proceedings if Democrats take House in November. Every sworn statement becomes evidence Congress could cite. But the contempt isn't the only legal problem Trump faces from this case. Sources indicate Judge Bosberg also found that the deportation program violated fundamental due process rights, and those violations might have independent consequences beyond the contempt proceedings. Reports suggest people were deported without proper notice, without meaningful chance to contest their removal, without opportunity to dispute gang allegations that justified deportation. Those are constitutional protections that can't be ignored, even for immigration enforcement. The Constitution allegedly doesn't limit due process to citizens. It says no person shall be deprived of life, liberty, or property without due process of law. That means everyone in the United States, regardless of immigration status, gets certain protections. Government can't just grab people and remove them without any process. Even if someone is ultimately deportable, sources indicate they're entitled to hearing, to present evidence, to challenge government's case. Trump's program denied all of that. Think about what Judge Bosberg has ordered. Reports suggest he directed the administration to submit compliance plan explaining how it will fix the violations, either by bringing deported people back to the United States or by holding constitutionally adequate hearings abroad. That's extraordinary remedy that creates impossible practical problems for administration. Bringing people back from El Salvador would be politically embarrassing. Holding proper hearings abroad would require resources and procedures that might not exist. And sources suggest simply ignoring the compliance order would invite further contempt findings. The judge gave deadline of January 5th, 2026. Whatever administration submits will be scrutinized. If plan is inadequate, confrontation escalates. If administration doesn't submit anything, that's additional contempt. Trump is in bind where every option has serious negative consequences. But there's reportedly another element. The due process findings establish that Trump's deportation program was constitutional violation from start, that it wasn't just procedural problem that could be fixed with better communication. It was systematic denial of rights that judge has ruled unlawful. That could become evidence in multiple contexts. lawsuits by people who were deported, investigations by Congress, potentially even criminal prosecution of officials who implemented unconstitutional program, knowing it violated rights. And now, Trump ran promising tough immigration enforcement. But if his programs are found unconstitutional by courts, if they violate basic due process, that undermines the entire approach. Democrats could campaign on Trump being so extreme even conservative judges find his tactics unlawful, that he cares more about looking tough than respecting Constitution, and those arguments might resonate with voters concerned about authoritarian tendencies. So, what actually happens now with Judge Bosberg's contempt findings and testimony demands? Because sources suggest several possible scenarios depending on whether Trump administration cooperates or continues defying judicial authority. If subordinate officials provide testimony that points upward in chain of command, that creates foundation for compelling higher-level testimony. Reports indicate Judge is working methodically through Justice Department and DHS officials. Each round of testimony either resolves questions about who authorized defiance or points toward higher authority who made the call. If trail leads to Trump, his lawyers would invoke every possible privilege and procedural obstacle. Sources suggest they'd argue that compelling presidential testimony about official acts violates separation of powers. That executive privilege protects deliberations. That president can't be distracted from duties by judicial proceedings. But Judge Bosberg has already shown willingness to push back hard against executive resistance. He might not accept those arguments without requiring serious legal justification that goes beyond just asserting presidential prerogatives. Think about timing implications. Sources indicate compliance plan is due January 5, 2026. Testimony from officials could come in weeks following that deadline. If pattern emerges pointing to presidential involvement, demand for Trump's testimony could come in early 2026. That's before midterm elections. If Democrats campaign on Trump defying courts and facing contempt, and then he gets ordered to testify, that could dominate political coverage in crucial months before voting. And there's reportedly another scenario. Trump could try replacing officials who might give damaging testimony. But that creates its own problems. If people get fired right before scheduled testimony, that looks like obstruction. It reinforces appearance of guilt, and new officials would face same judicial demands. Can't escape testimony requirement by shuffling personnel when judge has already found probable cause for contempt. But sources suggest most likely outcome is continued escalation. Administration provides inadequate compliance plan. Judge finds it unacceptable. Orders more testimony. Testimony points upward. Administration resists. Judge imposes sanctions. Back and forth continues until either Trump administration caves or constitutional crisis reaches breaking point where judicial orders simply can't be enforced against defiant executive. And looking closely, there's reportedly historical parallel. During Watergate, courts compelled Nixon to produce tapes despite his executive privilege claims. Supreme Court unanimously ruled that presidential confidentiality must yield to judicial process in criminal proceedings. That established precedent that presidents aren't above law. Judge Bosberg could cite that precedent if he compels Trump's testimony, and Trump's resistance would echo Nixon's defiance in ways that might not end well for him politically or legally. So here's what Judge Bosberg's contempt findings reveal about where Trump's presidency stands with judiciary. A federal judge finding probable cause for criminal contempt because deportation flights continued despite explicit order to halt them. Demands for sworn testimony from top Justice Department officials about who authorized the defiance. Methodical building of record working up chain of command toward whoever made final decision. Constitutional findings that deportation program violated fundamental due process rights, and compliance orders that create impossible choices for administration about how to fix violations without massive political embarrassment. The implications for Trump personally could be devastating. If testimony trail leads to him, if officials say they were following presidential directives, he might face choice between testifying under oath or invoking privileges in ways that make him look guilty. His history of avoiding sworn testimony because he invoked Fifth Amendment hundreds of times suggests how terrified he is of being questioned under oath. And given his pattern of making false statements even in depositions where he does testify, perjury risk would be enormous if he's compelled to answer questions about contempt. The constitutional crisis implications extend beyond Trump's personal jeopardy. This case tests whether courts can enforce orders against president who refuses to respect judicial authority, whether contempt power and testimony demands give judges real enforcement mechanisms or just theoretical authority that presidents can ignore, whether American separation of powers still functions, or whether executive has become so powerful that judicial review is meaningless. Those questions matter for democracy's survival, regardless of partisan politics. The political timing matters enormously for midterms. If Trump gets ordered to testify before November, if contempt proceedings dominate news coverage, Democrats could make judicial defiance central campaign issue. Argue Trump treats courts like obstacles to ignore rather than institutions to respect. Use his resistance as evidence of authoritarian tendencies. And combine it with all the other chaos and controversies into narrative about president who's unfit for office and Republicans who enable him. That message could drive turnout among voters who care about rule of law and constitutional constraints on power. Stay tuned.